Thank you so much, Joan, for such a generous introduction. I am really excited to join you all. I enjoyed kind of perusing your website, and it was a pleasure again to hear your mission and purpose articulated at the beginning of this call. I'd love to see that everywhere. I don't know if anyone's seen the coverage of Bob Putnam's Bowling Alone and the update to the present, but the idea was that there aren't enough ways that people are engaging one another in civic community. So it's really, for this law nerd, very heartwarming to see you all engaged and to know that you're interested in hearing me talk about one of my favorite things, which is judicial ethics. Um, to sort of distill your kind introduction, I am a two-time federal appellate clerk and one-time Supreme Court litigant. And the perspective that I offer, I think it's relevant that both of the judges that I clerked for were Republican appointees. And I mention that because it shows just how different the world has become even recently, where I don't know many other people who would say that they've clerked across party lines. And that's not the way things should be if our judiciary is working. As one of my judges said, she gave me homework before my interview. She said, "You need to read these 5 cases because these are the 5 cases you're most likely to disagree with me on. And I want you to read them and then we'll talk about them in an interview." And when I spoke with her in chamber, she said, "Well, I just see it as my job is to get it right." And she didn't mean far right or capital R right. She meant really my job is to get things right. And that is all too unfamiliar in today's landscape for the judiciary. So this morning, my plan was to focus on ethics vis-a-vis the federal judiciary with an emphasis on SCOTUS, because the Supreme Court influences the lower courts so much. That seems like a useful place to start. And a little bit of synecdoche. What's happening at the Supreme Court reflects what can or is happening below. And so the 3 subtopics, beginning with ethical issues, moving on to so what and what can we do about it? And then finally, what happens in chambers, sort of another aspect to the human side of the judiciary. I imagine a lot of this is familiar, but the primary ethics concern at the Supreme Court, and which is not to say that lower courts aren't also bumping up against these things, surround essentially the improper acceptance of trips and gifts and real estate deals, and the failure to disclose them, which is a violation of federal law. So it's not just a violation of well-known judicial ethics. I mean, any clerk can tell you it's the mere appearance of impropriety is to be avoided when you work for the judiciary, never mind when you're a judge. But it violates the Ethics in Government Act. And so it's been egregious. It's from luxury trips that Justice Alito and Justice Thomas each took, to Justice Thomas's nephew's boarding school fees, and a deal to buy his mother's home and several other homes at great financial benefit to the Thomas family, with Harlan Crow, the mega millionaire, billionaire in question, saying that he bought them for the explicit purposes of creating a museum honoring Justice Thomas. And of course, had also gifted something like a $17,000 Bible, and assorted other totally improper, way beyond the scale of what's permissible, perks. And then the second part, the not reporting, it's not just not reporting these gifts that shouldn't have been given in the first place. It's not reporting personal relationships to the parties before the court, or with parties who have interests that will come before the court. And an example of that, a very clear one, is Ginny Thomas's involvement in the attempt to overthrow the election and to cause an insurrection. She was up to her neck and all of that, with messages and ample documentation, and yet Justice Thomas decided not to recuse. So that's another big ethics problem. And Chief Justice Roberts, his wife, benefits financially. Her job is helping law firms that often have interest before the court, and that's a problem. And it's interesting as a data point to compare. I don't know if you've seen the memes, the headlines, but about the fact that Governor Walz doesn't own stocks. And like, well, that's refreshing, considering that one of the biggest ethical problems we have at the court is with some of the justices owning stocks that place them really directly sort of as interested parties in the cases that they're hearing. One other thing that I think this goes into the bucket of ethical norms, because unfortunately the Supreme Court does not have an enforceable code of ethics. They released a code of ethics that amounted to lip service, literally changing the ethics rules that all other federal judges have to obey, where those rules said shall or must. The Supreme Court's just said, was suggestive, like should or, might consider. So, but going beyond what's codified, the fact that the Supreme Court justices are trying to argue their case in the media, especially around ethics. So Justice Alito has made a habit of going to the Wall Street Journal and publishing his pushback there, which is paywalled. So that's the first sort of irony, which is, oh, okay, well, you're going to make a public statement about ethics at the Supreme Court and try and exonerate yourself from appearing to be an elite, wealthy person who's walled off. Maybe don't do it behind a paywall at the Wall Street Journal. And that happened because ProPublica, which if you haven't seen, they have a great landing page with their extensive reporting on judicial ethics. That was Justice Alito trying to beat publication of the latest revelations about the types of gifts he'd been accepting, a trip he'd gone on to Alaska, which he argued didn't constitute a perk because the seat would have been empty if he hadn't gone on this private plane. So, no harm, no foul, right? That's not how it's supposed to work. And my final category for judicial ethics concern is just the overt politicization that we're seeing in the judiciary now. We have Justice Alito on tape to the reporter he doesn't realize is a reporter who's gone undercover, saying that it's zero sum and one side will win, and making clear where he stands on that. And then just the fact that the Roberts Court voted to hear and then released astonishingly anti-democratic decisions in the three Trump cases, the January 6th case, the ballot case, and the presidential immunity case. And then, so I'm not sure, I'm trying to keep an eye on time. So my second category is just when we talk about why this matters and what the sort of larger context is, it's that the Supreme Court is rewriting its own role in American democracy, and in connection, the role of other institutions, for example, by granting presidential immunity. And it's rewriting not just through the rulings, but through procedural shortcuts. I imagine a lot of you have probably heard the term shadow docket, which has risen to prominence in the last decade because of the way this court is using it. The shadow docket is supposed to be essentially, it is an emergency orders list. If there's something that's very, very urgent that the court is being asked to hear or weigh in on. And under Roberts, it's been changed instead to where activists can attempt to lodge an often premature, for those of us accustomed to a more reasonable judicial environment, challenge or to seek assistance. And instead of being a procedural mechanism, it's become this way to covertly take and decide cases in a matter of weeks, even those that present the most substantive issues, rather than merely using it to straighten out procedural mishaps. And I mean, of course, they're not doing all of what they're doing to affect the institution in the dark. There's the shadow dive, but then there's, Dobbs, and Chevron, the demise of Chevron and Loper Bright. Chevron being a 40-year-old precedent that says if Congress hasn't specified agency experts are tasked with implementing Congress's intent with legislation, anything that's not sufficiently clear goes to agencies and their experts. And so by effectively overturning it, what this court has done is said, oh, we don't need experts. Judges can just make this decision. And I'm trying to remember, it was in her dissent or at oral argument, but Justice Kagan, I think in her dissent, had a pretty funny line. It's like, I have no idea what that molecule is, and neither does any other federal judge. We shouldn't be in the business of making decisions about, complex scientific concepts and concerns. That's why we have experts at the agencies. So this is a court that does not shy from overturning precedent, even extremely significant precedent. And sorry, harkening back to the shadow docket, the other thing this court's doing with the shadow docket is signaling the direction it intends to go in. So there was a pre-Dobbs decision in which the Supreme Court used the shadow docket to take a case that was similar enough and signal how it would decide this, which is sort of a way of alerting conservative legal activists as to what they should be prioritizing as a vehicle for attempting to gain ground. Pardon me. And of course, organizations like Alliance Defending Freedom have literally thousands of lawyers who do nothing but come up with cases, either in the literal sense of manufacturing a case. In 303, one of the most recent gay rights adjacent cases at the Supreme Court, it turned out there was no plaintiff. And that the individual that had been cited as the sort of cause for the case was, I think, a happily married straight man, not a would-be gay fiance. And yet conservatives use that case as a vehicle very effectively. So that's a thing to keep an eye on that's concerning. But and your very timely update, as I've recently been buried in the Supreme Court's last actions for the last term, and it has already signaled that in a similar way that it intends to either heavily revise or overturn Bostock, which was the one gay rights decision we've had in the last few years that was positive, which said discrimination on the basis of gender presentation, gender identity, and sexual orientation is the same thing as sex discrimination, and decided it for Title VII. So offering protections for the first time to LGBT Americans in the workplace. So, the EEOC, the Equal Employment Opportunity Commission, had already been doing this for at least a decade before, but it was a major victory, the likes of which we're not likely to see again, and one that may already have been overruled depending on how the court intends to interpret what it said about this case. And of course, it also recently signaled that it's hostile to Obergefell, essentially, which is the decision that made it possible for people of the same sex to get married. And I won't go too far into the weeds. I'll just leave you to, this is all part of a sort of march against substantive due process, which is simply the doctrine that says not every single right that Americans have under the Constitution is enumerated. It would be impossible to enumerate every one of these things. But these other rights exist in the shadow, the penumbra of the Bill of Rights. And that includes, marriage, contraception, abortion, being gay, since law often defines that as a matter of action rather than identity. So these are all part of a larger trend. And as part of it, Supreme Court justices are just cherry picking to a degree that is much more radical than any predecessor court, and signaling in their decisions what they're ready to take or hear and how they should be brought at the court, how issues should be presented before the court. So it's just a really astonishing way of working pretty much in the open with conservative legal activists. This might be kind of controversial, but I'd also say, ethically, it's a bad thing that the Supreme Court's producing shoddy work. and it is. The immunity decision was really poorly formulated and not well argued. And so, if it weren't enough for you that almost 55% of the American public has a negative view of the Supreme Court based on what it's doing in sort of broad strokes, with only 36% approving, it should be of concern to everyone that they are quite literally bringing down the quality of legal practice. And I think that's also very telling with respect to how politicized they are. But just to see the Supreme Court producing bad work, that has implications that will last more than a lifetime in some cases. And it's a loss of integrity and trust at stake when the court is producing things that are overtly driven by politics rather than law. And I think that's, as we would say in the legal profession, res judicata. It's the issue has been settled. I think it's impossible to argue that the Roberts Court is not political, especially given the very recent disclosure of a February memo that Chief Justice Roberts wrote about taking the Trump immunity case, not just that they should take it, but how it should be decided, which is not the order of operations that the Supreme Court is supposed to be following. So my final point is one that I just don't see covered a lot. It's, there will be sort of an uptick in interest as scandals happen, but we don't talk a lot about staff and their treatment and their opportunities for recourse, those who work in the federal judiciary, which are very few, and they're even fewer for clerks. And why does this matter? Because clerkships and feeder judges, bonuses, student debt, credentials, this is all tied up, and the legal profession is obsessed with clerkships. And that's a problem for a number of reasons. You have, while grades and journals and all of that affect whether or not someone is competitive for a clerkship, the thing that matters most is essentially insider connections. Does the right professor want to recommend you? Is Judge so-and-so a family friend? And then in addition to all of the sort of barriers to getting a clerkship, which is, often considered a prerequisite to becoming a judge or to entering sort of the upper echelons of the legal profession. And in addition to all of that, you have to be able to afford to clerk. There are only 3 law schools that I know of at the moment that help students based on financial need and offer assistance paying back student loans. Yale, where I went, only in the last few years created an entirely need-based category of scholarship for students, which is enormous, but it will take a very long time to change the profession. We need more schools stepping up to do that. And the salaries that clerks get are so low that at Yale, you actually have to take out a clerkship loan to pay your other student loans while you're clerking. And what that does is it pushes people. I clerk because I love the law. I'm a hopeless nerd. And I hated the one summer I was at a law firm. But if you don't have a school that's as generous as Yale, you don't have a lot of options if you're going to clerk, because the setup is you clerk, and then if you go to the law firm, you get up to $75,000 as a bonus for one federal clerkship, and you can stack those as many as you do. And last I heard, I mean, when I was in law school, it was a $250,000 bonus was common for a Supreme Court clerkship when you go to a firm. So even as the cost of education is rising, there aren't comparable mechanisms for defraying that cost or making it possible to pursue that experience. And I would argue that it just especially affects those of us who go into public interest law, because, without that bonus, it takes much longer to pay off student debt. And it incentivizes, I think, not following, I mean, I'm particularly rooted in social justice, but not following whatever calling brings someone into law. When you place so many institutional and financial barriers to actually becoming a public interest practitioner, or policy wonk, as opposed to going to a firm and doing whatever type of law you need to do for as long as you need to do it to pay off these enormous loans. One of the things that's hard about this system too is because it is so important, and because clerks do work so closely with judges, it's very difficult to get good information about judges. And those schools that even are well enough resourced to maintain databases about judges, don't put negative things in them by and large. They discourage students from doing so. So I didn't know until I was clued in on this by an older classmate. There are phrases that when you read them, you sort of know, okay, that means, if someone's just left a review and all they say is, call me if you're considering this judge. You know what that means. And I mean, as long as clerkships are this sort of bottleneck between law school and entering the profession at elite levels, or getting a job at a firm that will allow you to build a family, and as long as they're this bottleneck, people are not going to be willing to speak openly about judges, and they're not going to do anything that might imperil their chances of getting a clerkship. Where that is most devastating is when people are serving as clerks and being subjected to sexual harassment, hostile workplaces, other forms of discrimination. And not only can they not talk to other people necessarily because they need that recommendation, they need that judge's support. That's the whole point of the year. And they've got schools telling them not to talk about it. They don't have recourse for reporting the judge. It is extremely rare. Well, I'd like to think, well, the judiciary, what's even rarer than a bad judge is the opportunity to actually report on this person and see them held accountable. So Judge Alex Kaczynski of the Ninth Circuit, who is a judge for at least 3 decades on federal courts in California, had been sexually harassing his clerks. And he was one of the few that I'd heard about when I was in law school for 3 decades before 15 women finally came forward and were able to initiate investigation. Judge Kaczynski retired with his full pension. He did not lose his law license. He's gone back to practice. And that's, even if you get as far as someone being held publicly accountable in the sense of their behavior made known, the consequences for judges are just nil. A more recent example is Joshua Kindred, who was also in the Ninth Circuit. He was the district court in Alaska, a Trump appointee, one of 234, tragically. And I mean, reading about his behavior is terrifying. There's a wonderful project that I would recommend that folks who might be interested in protections for judiciary staffers and clerks take a look at. It's the Legal Accountability Project. And they do a very good job of laying out in much more detail the things that I've just alluded to. So yeah, I mean, a little thing, but an example: when you clerk, the presumption is you don't get time off. And so the judge has to affirmatively check the box that says that you get federal holidays. Otherwise, you're not entitled to be sick, you're not entitled to take vacation, you're not entitled to spend a holiday with your family. So it's this very strange, antiquated system that both is a bottleneck and has a chokehold on members of the legal profession that are definitely cause for concern. So I will end on a positive note and with a mind to heed your mission about how we move toward a more just society, and talk a little bit about some of the legislative fixes that are being circulated right now. There's a No Kings Act, which is a direct response to the Trump immunity decision intended to fix it. There's CERT, the perhaps problematically cleverly named Supreme Court ethics bill that I think has gotten the most coverage. There's the Judicial Accountability Act, which combines fighting judge shopping, which is what members of ADF do, for example, when they bring cases before Matthew Kacsmaryk, knowing that if they go to this northern Texas district, they've got a surefire shot at getting a judge who's going to be hyper sympathetic. Kacsmaryk being the judge who made the initial ruling on mifepristone. And then from there, conservatives take cases directly to the Supreme Court, which is, again, not how this is supposed to work. You usually get a decision at the district level, deal with it at the appellate level. Then there's an attempt to get the appeals court to hear it en banc, or all judges of that court, or otherwise appeal. But all of these layers that should proceed going directly to the Supreme Court. So judge shopping is a major problem and falls into the category loosely of procedural mechanisms that are being abused. Two other acts are the Term Limits Act and Battle. I just love that it's called Battle Act. I'm like, Battle Axe, Battle Act. But what each of these pieces of legislation, the main ideas that they share are term limits, either 15 or 18 years, depending on the piece of legislation, and staggered appointments. So every 2 years, there's a new justice, sort of trying to even out the ideological aspect or skew of the court. And at the end of these terms, I think each of these pieces of legislation, with some variations, say it's just the type of case that you're hearing changes. But it's a way of trying to diversify the court and prevent, as we see now, a majority from having undue influence. And each of them takes a different approach, but I think all advocate for the creation of some sort of mechanism for holding Supreme Court justices accountable, whether it is an ethics council within the judiciary or it's a separate body entirely. And if not legislation, the options are fewer, but justices could be and should be investigated by the Department of Justice at this point, given the severity and frequency of the misconduct. And unfortunately, the way that that's most likely to happen, or historically would be through the Judicial Conference. And because they've been so unhelpful on judicial ethics, I think we're not really holding our breath on that one. But there are a few different avenues, and a DOJ investigation would be preferable, I think, to the final option, which is impeachment. And if it sounds drastic, it's actually not. It's I've been, for whatever reason, researching impeachment of executive officials for almost 10 years now. But impeachment is supposed to be the mechanism by which office holders are held accountable. And in the case of the Supreme Court, the Constitution even specifies that justices hold their office contingent on good behavior. So looking at the history of what you can be impeached for as a judge, from, appearing drunk in court to whatever else, it's just what's happening now is at a totally different scale. And so it has been heartening that there's been more impeachment talk. Joshua Kindred, the Alaska judge, in their investigation internally within the circuit, the body that investigated him recommend that Congress consider impeachment. And that's a pretty big sea change, to have a body within the federal judiciary saying that impeachment is the appropriate remedy, potentially, for judicial misconduct. So hopefully the Overton window is growing a bit on the impeachment issue, because there's absolutely no indication that the Supreme Court intends to police itself or hold itself accountable. And if anything, I think there's growing evidence that it's the opposite. So I don't know how you usually do things. I'd be happy to send links to some of the things I've mentioned. In particular, I was thinking of the Roberts article that makes clear just how deeply responsible Roberts is. Although often people give him a sort of, pass, or think of him as more moderate. Anyone who looks moderate next to Clarence Thomas, I mean, that's a pretty big spectrum. That's an enormous range. Clarence Thomas makes it pretty easy to look moderate. So yeah, I would love to share the Roberts article in particular, also because it just gives very good context for some of these ethical procedural errors. And with that, I defer.
Okay.
Would love to talk more.
Thank you, Rebecca. At this point, we usually have a bit of a Q&A, not so much to, well, let me put it more positively, to ask Rebecca any additional questions that you might have related to her content. And I have one, Rebecca, as a private citizen, is there anything I can do? Anything we can do?
Yes, absolutely. I think one big thing is calling your congressperson, calling especially your senator, since judicial appointments go through the Senate, and saying, hey, I really care about judicial appointments. Because we can't bet on when there will be another opening on the Supreme Court, but we can ensure that we diversify the federal judiciary and that we have as deep a bench as possible of judges who would be eligible to move forward. And change the system from the ground up. I know that offices, when we work with Senate offices, they say that it really does make a big difference when people call and they say, I'm concerned about seeing this judicial nominee through. They've been waiting for a vote in the Senate for X months. Or obviously you can call and say, I just wanted to express my support for whichever of the pieces of reform legislation you would care most to see, or just say, I care about Supreme Court reform. It makes a really big difference in staffers' perceptions of what is important to senators and congresspeople, especially in this moment when everyone is so busy with the election approaching.